Welcome to Overtime 201 Part 2. My name is Lee Jacobs, and I'm joined with my esteemed colleague, Rosemary. Good afternoon.
Hey Lee, how are you doing?
Good. Excited to continue our conversation. We hope all of you took a lap around your block or whatever it may be around the office, grabbed a cup of coffee as we continue our further discussions of high-level overtime topics. So, Rosemary, jumping right back into it, you were talking about an audit that one of your clients is currently facing. And one of the issues that you raised was the overtime true-up nightmare that we talked about. But were there any other nuances or interesting things that are beyond just 40 hours per week, the simple math, simple knowledge?
Yeah, actually there is Lee, and what's interesting is the issue I'm going to talk about came up in last week with another client. So two in the same week. So it was interesting. So this client has they it happens to be a restaurant, and and it is family owned. They have two other restaurants in the area, Lee. And, there's the miles and miles apart, but it's common ownership. All right. So it's common ownership. The employees can work between the different restaurants. They order the all of the supplies, the eggs, the flour, the milk, all of that, and it's distributed out to the different restaurants. But each restaurant has its own name. It's a different name, and it has a different tax ID.
Different payroll, different, like the checks are different.
Yeah, absolutely. But it is common ownership, and as I said, the employees go between the locations. And I'm going to steal something from you, Lee. They all go to the same holiday party, and so and it was a purely innocent mistake. But the individuals, so I'll say myself, I'm working at one of the restaurants in the morning for 4 or 5 hours. Then I go to the other restaurant and help out there for a few hours. And then the next day I'm at another restaurant, I work 10 hours. Well, lo and behold, by the end of the week, in total, when I would total up all those hours, I might have worked 50 or 55 hours, but it was spread over all these different locations or these different businesses.
And different paychecks. I got three different
I
paychecks.
got three. That's exactly right. So in the one, I got paid for 20 hours, and over here, I got paid for 25 hours. And for this over here, I got paid another 30. Right. So no overtime pay. Okay?
That's the problem.
It's a big problem. That's exactly right, Lee. It's a big problem because that is what we call joint employment, right? It's a joint employer. So it's common ownership. All right. They direct, all right, these individuals. And so if I'm working in any one of those restaurants, the hours are all go, how would we say it, Lee? Together, you total them. All right. They are not, even though it is a separate business, because it's at a different location with a different name and a different tax ID, they're joint employers. And the employees are going between. And so the reality is I am in fact owed overtime because I worked more than 40 hours in a work week. Doesn't matter that it was in these different locations.
And here I think spot on this is the intent, right?
Right.
It sadly doesn't matter that the business did it this way, not knowing to avoid overtime, right? So it doesn't matter that there was no intent, right? I'm certain that your client, if they knew, they would have paid overtime.
That's right.
But it's just probably it's the way it's always been done, and there's never been a problem until now, and unfortunately, it's been discovered. I can't remember when, but Rosemary, you and I have these conversations all the time. I can't remember the specific topics, but when you ask me what my thoughts are, before I even look up the actual rule or the law, I get to my gut feeling and think about, can someone exploit this, right? So take the joint employer narrative and have someone with bad intent. Well, if someone wanted to avoid paying overtime, if I had one business, I can just have multiple payroll entities within that same business. And I can assign you to 2020, 2020, and you never get to overtime.
Yeah.
And I'm doing it intentionally. clearly that shouldn't be allowed and the law wouldn't condone that. And so you take it further to this concept where you have different disparate businesses. And this isn't just hospitality, folks. This is all businesses. Imagine you have a family business that's on a block. You've got a nail salon in one place, a hair salon down the street, and then across the way there's a beauty supply store. And they're all sharing, not hospitality, sharing equipment, sharing supplies, go to the same holiday party. It's a problem.
Yeah.
And people don't know about this. And another way that people are trying to subvert this, that I've seen with my clients here in the city, is what they'll do is that they will hire back of house workers or janitorial staff, people who are going to be working overtime for extended periods of time. They'll partner with like a temp agency or a cleaning agency. And while that employee may be an employee of the cleaning agency when they're doing cleaning in the morning or night, they're actually an employee of the business during the day. But when they're actually there cleaning, it's still the business, not the temp agency, that's telling them how and when and where to do their work. And their actual work is for the benefit of the business, not the temp agency. There's been some cases down here in the city that says this is a problem because think about it. Of course it is. I'm just trying to offload this to another secondary business that I don't have any control over because I'm paying the temp agency that's paying you. So we look to the intent of what's going on here in some of these stuff as well.
Yeah.
So
yeah, you're rightly. And, you look at it and you think about it. I mean, literally their understanding was these are different businesses with different
exactly
IDs. All of that, and so how did it, so the intent, exactly. The other thing, Lee, is, for those of you who were listening to the, 201 part 1, we were talking about, remember, don't rely on your payroll company. Here's another great example.
Yep.
Right. So they all use the same payroll company, but they can see all the information. They didn't say, oh, hey, wait a second, you could be running into a joint employer issue here. You may have an overtime issue. Again, they literally are going to look at the time card, put it in the system, cut the check.
Yep. Bad data in, bad data out.
That's exactly right. So, and I can't tell you how many of my clients say, why did my payroll company not tell me? And I'm not throwing the payroll companies under the bus. It's not their job. That's not what they do. I think that's greatly. Bad data in, bad data out.
Yep.
The way it is. And so that's why it is so important for you to understand, dear listeners, what you need to be, how this needs to be managed, right? And how all of this works. Because you can't, a defense is not, well, my payroll company didn't tell me, so that's just not gonna fly.
And don't think then you can probably then turn around and sue your payroll company for the mistakes, because odds are in that agreement you signed with the payroll company, it literally says bad data in, bad data out, in so many legal words.
So many legal words. That's right. That's exactly right. Yeah. So that had come up, and the other thing that came up, Lee, was this whole thing around, because it's a restaurant, they were taking the tip credit. And then of course they had to work overtime, or these individuals worked overtime. And so the way that the overtime rate of pay, which we just went through, several examples of how you calculate, was not calculated properly. And and this is the U.S. Department of Labor, Lee, and what the U.S. Department of Labor investigators said was, this is the most common mistake in the hospitality industry. So an industry that is taking the tip credit. So Lee, this is really your area. So take a minute or two or three and talk everybody through the right way to do it if you're taking the tip credit for your employees.
Sure, absolutely. So for our non-hospitality people, here's your permission to go grab another cup of coffee if you want, but I highly suggest stay with us because the credits that we're talking about here still apply. You know, the way you do the math, even though we're talking about the tip credit, the same way is calculated. So I'm going to share my screen here, and I'm going to put up the LS54. Okay, so the LS54. The LS54 is a notice for hourly rate employees. I'm looking in the middle column here, line number 3. I have blank per hour. This is at least minimum wage, $15 or more. Line 4 has allowances taken. So let's presume we're doing $15 per hour is written in number 3. I check the box for tips because I'm taking the tip credit, and I can take up to a $5 per hour tip credit. Now, for those of you that don't know, the tip credit allows an employer to pay their employees below minimum wage so long as they are making up that tip credit deduction of $5 per hour in tips by the end before the shift is over. So I have so many of my clients that just say, yeah, in upstate New York, I can pay you $10 an hour. In downstate New York, it's $11.35 or so and change. But no, that's not true, because what that winds up happening is someone goes, I'm paying you $10 an hour. So I'm just going to write 10 here in box number 3. My tip credit being 5 because it's a credit. So I'm doing the math of 10 plus 5, and that's really the overtime. And then I jump down to 7, which is giving my overtime pay rate. And I'm just going to do 10 times 1.5 and come to $15 an hour. No, unfortunately, that's wrong. What it is you are paying your employees $15 an hour with a $5 tip credit for an effective rate of $10 an hour. And I've been drilling this into my clients for years. You have to stop saying we pay you $10 an hour. No, unfortunately, it's the full line. $15 an hour with a $5 tip credit for an effective rate of $10 an hour. Because the way you do your overtime math here now is $15 an hour times 1.5 comes to $22.50 with a tip credit of $5 an hour for an effective rate of $17.50 per hour. So the difference there was $15 an hour by doing it the wrong way, taking the tip credit at the beginning, versus $17.50 an hour, $2.50 per hour. You have someone who works, say, 20 hours per week in overtime, $50 per week, 4 weeks a month, $200 a month, times 12 months in a year, $2,400 a year, in a look back period of 6 years in an audit. So that's $15,000 or so per employee. That can be doubled. And if you're doing this with nefarious purposes, maybe even tripled with interest. Not good.
Yep.
Not right.
Yep, exactly. Well, and as I said, Lee, that's why I wanted to pose the question to you, because she said it is the number one mistake that everybody makes. They base it off, like you said, off of that $10.
And so then, and for some, there are some positions within the hospitality industry or any industry where you can tip. Well, I can't imagine in others where there would be tips, but any other industry where you can take a meal credit or a lodging credit, something to that extent. The same thing applies. It's the full hourly rate times 1.5 minus the tip credit. So you've got the best sommelier in the world who's being paid $100 an hour for their shifts, right? They're but we still take the tip credit. So they're $100 with a minus five for an effective rate of 95. Their overtime rate is based upon the 100, not the 95. It's always the full hourly rate. And I could wax poetically for hours and hours, Rosemary, but I don't want to bore the non-hospitality people about when you can take the tip credit or not. But just very, very briefly, there are so many rules that you must be in strict compliance about the tipping. One is you have to have the right documentation. Your employees need to know about it. This form needs to be correct. Your tip pool needs to be true. You can't have non-tip eligible people in your pool. So that means managers, back of house workers, et cetera, that are sharing in tips if you are sharing tips. And you must have documentation that shows tips in and tips out. So I've received X amount of tips on behalf of my employees, and then I've distributed them to my employees in this method, this manner. You don't do any of those things, you lose the ability to take the tip credit. So I had a client, Rosemary, in the hospitality industry that faced a DOL audit where it was started all for unpaid spread of hours. Uncovering through the unpaid spread of hours, they looked at the tip credit. They found that there were managers in the tip pool, and then therefore, for every single one of their hourly employees over the entire 6-year period, they needed to refund the tip credit of 5-4 over the years it's changed for every hour worked, plus the amounts of tips that were illegally distributed to the managers. And the Department of Labor won't take the money out of the managers' pockets. They're going to take it, make the business pay it again. So these employees who were already paid well over minimum wage because they were tipped well, now got a windfall because of a simple spread of hour error where they weren't paying spread of hours. They now needed to pay $5 an hour for every shift that every employee worked, as well as refunding the tips that should have gone to those people. Tricky stuff. Tipping is tricky. Let us help you, please, please. And again, don't presume your payroll companies know this. Don't presume they know this.
Yeah, and it's scary stuff, Lee, when you hear all these numbers and these horror stories, but it's reality. Everything we share with you has actually happened, right? So all right, so Lee, let's see. So we've talked about how to calculate it. We've got a salaried non-exempt. What else? What other questions do we have that we wanted to share?
Sure. So one that I get is, and this is industry agnostic, right? Mm-hmm. Presume you've got a warehouse, some type of construction facility, a landscaping company, something to that extent, and you've got someone who has 2 jobs. Let's go with the landscaping company, someone that's got 2 jobs. They like to be in the field, literally, on some days, right? And so they're paid 1 hourly rate when they're doing that work, but they are also the landscaping company's web designer because they are really good with the computer as well. Yeah. And when they're the web designer, they're paid a different hourly rate. Rosemary, does this pose a problem when you've got 2 different hourly rates and you're working for one company, or even 2 different companies where you've got a joint employers, right? 2 rates, 2 different businesses, right? Boom, head explode.
Exactly. I was going to say, it's not a problem. You just need to know how to do it. And by the way, I want to comment that this person is clearly a Renaissance person, that they work in the field and they're a website designer.
Yeah, love it.
Person, exactly. So, it's interesting. So, I try to keep it as simple as possible, but there are 3 different ways to deal with this thing, right? And again, I just went through this with another client with a DOL audit. That's where a lot of this comes out. So the first and the easiest, I don't know, Lee, if you've had this occur, but the individual is making, one rate of pay, the other rate of pay, and, they're obviously one is higher than the other. The DOL's position is, if you just always pay them the higher rate of pay, no harm, no foul. You don't have, and I'm sure you've had that experience.
Yep. Essentially, I 100%. If the employee wins,
yes,
right, the DOL isn't going to care.
That's right. If and that's literally what this particular investigator said. If you want to pay them more, have at it. So if you're paying them the high rate of pay, don't worry about it. The second way is rate in effect, which I always find to be a little hard, Lee. I don't know if you find that to be difficult, but basically what that means is, as the name implies, whatever rate is in effect. So whatever they're working, so they're let's say they're sitting doing the website design, and they cross over into that overtime threshold, so it's over 40 hours, the rate in effect when they hit that overtime, so 40.5, 41, 42, that is the rate upon which you're going to base their overtime. But I just think that's hard, don't you, Lee?
And it's wrong. Not
Yeah.
only is it's so, well, first, if that rate in effect is the higher of the two,
And we
we're
don't,
good.
we're good.
The employee wins. But if that's the lower of the two, that's a problem because what was we're going to talk about, and I'm going to put up another one of these wage acknowledgement forms in a moment, because you have to find before you even do that, for viewers, if you're watching us on YouTube, you'll see me doing the Monty Burns thing, right? Imagine
Austin Powers, no, isn't
yeah,
it?
or else, like get evil here.
Yeah.
Imagine an employer that says, all right, I know I'm going to have these overtime workers, and now I'm the landscaping company. I'm going to be nefarious, right?
Yeah.
I know that, so I know I'm paying them more as the web designer. So in my work week, I'm going to have them work 30 hours
Yep.
as the web designer at the beginning of the week. And
Yep.
then when they're making $20 less per hour, then I'm going to put them out in the field. Now my rate in effect is much lower, and my overtime rate's going to be lower. That can't be right, right? The Department of Labor will go, the employee is clearly losing here in this scenario.
Mm-hmm.
So the answer is, dear listeners, and I'm putting up on the screen, the LS55. And the LS55 literally gives us the information, shows us the answer.
Mm-hmm.
So you can see on the LS55, it has, I'm in the middle column, line number 3, it has how much per hour the employee is making for, and literally state, web designer, lawn care, whatever it is for their different roles. Again, in column 4, if we're taking any tips or any other types of credits or allowances, and I'm jumping down to line number 7, overtime pay rate for each type of work or shift. So here, if you, for example, if you're just going to make this administrative easier for yourself, and you just want to pay the higher rate, you just have the higher rate and say it's going to be the higher rate. And so if my higher rate is $20 an hour, so 20 times 1.5 is 30. So I just rate $30 an hour. Department of Labor is going to say you win. Okay. But the reality here is, if you truly want to pay the real overtime, the term of art is something called a blended overtime rate. And the way that you do that is by creating a weighted average. And the weighted average is created by totaling the regular pay divided by the total hours worked in the week. The overtime rate may vary from week to week, depending on how many hours you worked at each rate of pay. The overtime rate may vary from week to week. I literally read right from the form. So what you do is you add up all the hours worked, you divide by the amounts necessary, and you come up with a blended overtime rate. Your payroll provider should help you with this. This is not something that they may not. Some payroll providers know this automatically and automatically do the math for you. Others don't, and will just default to the rate then in effect. And as we just talked about, that could be a problem. So you've got to be careful, and you've got to watch this. There's spreadsheets you can Google and find that will help you do this, where you plug in the number of hours and each rates, and it tells you what the amounts to be paid. And the other thing to think about this is that you've got to make sure your pay stubs are clear here as well. Your pay stubs, presuming this is one business with one payroll entity, should have each line of 10 hours web designer, 40 hours lawn care. So that way we can assert the records are there year after year after year. And this same issue here is for joint employers. You've got payroll entities over different businesses with different rates. The same thing is going to apply, that you should either choose and embrace the highest rate or work on a true amount and figure out the blended overtime rate. And that's going to change every single week your employees work. So the question here is that I have to my clients, or that I pose to them, is you either got to make sure your payroll company knows this down cold, or your internal processing knows this down cold,
right,
or just don't do it.
Yeah. Exactly.
Just don't do it.
That's right. That's exactly right. Yeah. Well, and we've been working with a payroll company and for 2 weeks now to help them, teach them how to do this. And they are so struggling. So that's your point, Lee. It's like, well, we may just have to do it in house, and you give them the information because, like you said, if you get this wrong, it's a problem.
And I think that speaking over the things that we've talked about in both of these sessions of overtime 201, like with the true up nightmare with the bonuses.
Mm-hmm.
So if you're going to give a contingent bonus, don't let your employees work overtime. Then you don't have, then the problem doesn't exist.
Right.
Exactly. Or if your employees work overtime, don't give them a contingent bonus.
Yeah.
And then the problem doesn't exist.
That's right. Exactly. Yeah.
It's and unless you've got the internal framework or the external support, we're human beings. Someone is going to make a mistake here, and these mistakes are gonna be so costly for you. Yeah. So costly.
But luckily for you, what generally will happen is your employee, has been kind enough to keep track of all the hours they worked and how they should have been paid, so that when they then come forward and say, "Oh, look," and you don't have any documents, that would confirm. I'll do it in the positively, that would confirm that. Well, then you can just pay what the employee says, right? And that's what the DOL does. And so, and yes, I'm being very facetious and sarcastic there, but it is unfortunate. I've had that happen to several clients where the employee said, "Well, here's this notebook, and I've been recording everything in it," and they turn it over, and the client doesn't have, back to what we talked about in the first episode, Lee, of 201. And we said, on the wage statement, it just says regular earnings. And, and in fact, it isn't regular earnings, right? Part of that is sick pay or holiday pay or PTO or something. But all of a sudden you've got an issue, right?
And you may be saying to yourself, who keeps a diary? Who actually writes? Rosemary, I beg to differ. Hi.
Do you really?
Not now, but when I was an hourly employee, my mother told me before I started working, she goes, this is back in the day when you had like high school planners, right? Yeah. Like I had a paper every day. I would write down the number of hours that I worked per week. And I would just keep it in my diary contemporaneously because my mother I don't want to use the wrong word here, wasn't fairly paid or appropriately paid when she was an hourly worker.
Okay.
So all it does is it just takes one employee. I have a client that's being sued here in New York City in federal court. He paid all of his employees quite well over minimum wage, but he paid them on a weekly amount, and he has no proof of the number of hours per week that the employees work. No schedules, no time cards, no anything.
Wow.
Nothing, because that's the way it's always been done.
Right.
And it just takes one employee to complain. And unfortunately, as you know this, Rosemary, the law is very clear. If you don't have the records, the employee's version of events will control if it makes common sense.
That's right. Well, that's my point with the diary, Lee. That's what I said. You're going to have an employee come forward. Here you go.
So the employee is going to say, we know the employee only worked 50 hours per week, but let's say now they've got a nefarious plaintiff's attorney whispering in their ear. That plaintiff's attorney is going to say, well, you work 60 hours per week. And if the business is open and there's enough hours to show under a common sense assessment that you work 60 hours per week, odds are the Department of Labor and or a jury or a judge is going to accept the 60 hours because you, business owner, were required to keep those records. And I know, listeners, you've heard me say this before because it was a real life example. It does not matter the reasons why you don't have the records, whether it's because that's the way it was always done, whether your dog ate the homework, or you lost them in a flood during Hurricane Sandy and you have a video of the records being washed out to sea. It does not matter.
Correct.
I don't know if that's on a point to scare the viewer, our listeners at the end of the episode, but we've been going for about 30 minutes here. I think this is a good time for us to take a to say goodbye for now on this topic, Rosemary. What do you think?
So. I agree. I agree. But what we'll say is, if you have a question, all right, shoot us an email, and we are happy to discuss it on the next podcast. You know,
Yep,
happy to. If there's something that you think we missed or you weren't clear on something, please reach out to us.
And building on that, Rosemary, I think please like us on if you're viewing on Spotify, any of your podcast listeners, YouTube, et cetera, like or subscribe. Please please let us know that you're out there. Comment, send us questions, and because we want this to be as interactive as possible. And so to that extent, here are the questions for our Spotify poll listeners. 1, were you aware of the true up nightmare? Yes or no. Question 2, and I think this is literally one now. And if not, you were unaware of the true up nightmare, is this now a real nightmare for you? Yes or no. Question 3, do you want us to focus more on the joint employer issue? Do you still have some more questions about joint employment relationships? Yes, no. And then question 4, what would you like to hear about next? And here's 5 choices for you. A, navigating the complexities of employee benefits. B, legal considerations for remote workers and digital nomads. C, best practices for creating compliant employment contracts. D, strategies for managing workplace diversity and inclusion. And E, the impact of emerging technologies like artificial intelligence on labor laws. Let's let you tell us what you want to hear from us next. And if anything different, comment, email. We're here to help and here to listen. Rosemary, what do you got?
So, Lee, I was just going to ask: do they get to rank them? Do they get to say like 1, 2, 3, 4, 5, or do they check every one that they want?
I believe there's going to be check boxes, so you can check on the ones that you want. There'll be multiple choices for you.
Perfect. Okay, good. Great. And please do let us know. We're happy to talk about anything and everything, but I think you know that because you've been listening to us.
and continue the conversation. So many of you have reached out and given us asked questions. You know, we're here. We're here to help, and we love these, and we look forward to speaking to you next time. Yeah. Thanks, everyone.
The Labor and Employment Podcast is available on barclaydamon.com, YouTube, and all your favorite podcast streaming platforms. Like, follow, share, and continue to listen. Thanks.